Hey, gun people! Continuing the class on exigency, understanding it, understanding how the courts are going to determine what they're going to determine and what cops can and can't do and what's your rights and how do you protect those rights. Here we go. People versus Toure? We'll call him Toure. Did exigent circumstances justify a warrantless blood draw from a combative DUI arrestee who had caused an injury accident? So this statement is warrantless blood draw, meaning the guy didn't consent. He's saying no, so you hold him down and take it, which is authorized in California. I can't believe it. It's always the liberals who have the most tyrannical laws. So anyway, in California, I can take your blood if you say no. I can hold you down and take it, unless that's changed. But when this was done, obviously 2015, it was still good. So warrantless draw, combative, meaning he was saying no. There's no confusion that he consented. And then he had an accident that caused injuries. That's probably the kicker. Had he just been stopped in his driveway and been combative, I don't know if this would have flown. But because he had an accident with injuries, and why accident with injuries is so critical is because if someone dies after an accident like 6 months later, it turns into a homicide. So when you have injuries, especially injuries that could likely cause death later, you really want to do a really good case in your investigation, because when it turns out to be a murder 6-8 months later, and now you go back because you did a shitty case because you thought it was just a little injury, you get screwed. So anyway, those are just lessons from getting caught up in that shit. Here we go, some facts. Approximately 9 p.m., so it's 9 p.m. at night, it's dark. Mr. Toure was driving a tractor-trailer rig westbound on State Route 58, San Bernardino County. Witnesses said Toure started swerving into eastbound coming lanes. Now, sometimes this could be because he's sleepy. But anyway, he didn't just swerve, he actually hit a car, causing several oncoming drivers to take evasive action by running off the road. So that proves he was definitely a danger before. Either he was too drunk to know it, or he didn't care, or he was under the influence of drugs or alcohol, maybe both. Toure eventually began driving continuously in the eastbound lane for about 2 miles. That's a long time to be in the wrong lane. At which point he crashed into an oncoming car. That could be a bad day. Both occupants of the car were injured. No shit. Toure kept going for a while after a tire blew out. He then momentarily stepped down from the cab, mumbling to himself, but then got back inside and said something like, "I'm out of here." Fearing that Toure was going to drive off again, one of the witnesses reached in the truck and removed the hitch key. I've done that before. I was off duty. Some crazy woman was all over the road running in. And actually, I didn't do it. The crazy girl I was with reached up and did it. I went, man, you're freaking crazy. Anyway, so Toure was to drive off. One of the witnesses stepped up and removed the hitch key. Now, this witness, what's her liability for seizing this guy's car? None. She was acting reasonably to protect people's lives. And although she doesn't have immunity granted by government will give her immunity because what she did probably saved lives. And no DA is going to prosecute this woman for violating Mr. Toure's rights to his car, for literally seizing his car and seizing his keys and stopping him from driving. It's not going to happen. Even though technically the pesky citizen had no right to do that unless you give them the exception, kind of like exigency, to act to protect public life. Okay, then CHP showed up, of course. This is after they've had a wreck, after the guy's got it. This is minutes later, maybe hours later, CHP comes to the rescue. The CHP, those guys are good. They got a show on TV. Anyway, CHP officers arrived at the crash site and determined that the ambulance was en route. Wow, that's pretty good determination. CHP's on the ball. They drove up to Toure's truck and found him in the driver's seat holding onto the steering wheel. One of the officers opened the passenger door and ordered him to step out, but Toure just yelled obscenities at the officers. Good job. CHP need to hear more obscenities. They're freaking... Anyway, I digress. After pulling Toure out of his truck, they pulled Toure out of his truck, the officers ordered him to turn around so he could pat search him for weapons. But Toure clenched his fist, spun around, and tried to hit one of the officers. Darn, he missed. Toure was eventually handcuffed, but continued to yell, spit, and kick at the officers. So it's fair to say that Toure was overtly exercising his non-compliance and he was not consenting to anything. So he didn't even have to say that. We can tell by his actions. There's no confusion. Mr. Toure was not consenting to anything. The officer immediately saw and smelled various classic signs that Toure was intoxicated. Ooh, that was fancy. But they were unable to administer a field sobriety test because he was so combative. Okay, no field sobriety test. He's wrecked. He's driving crazy. He smells like alcohol. He's fighting. He's aggressive. He reeks of alcohol. They have enough to go get blood. So, after arresting him for DUI, they drove him to CHP office in Barstow where they notified him of the California implied consent law. That's basically, it says, hey, you got a license. You implied consent. If you don't consent, we're going to suspend your license. When an officer asked him if he would submit to a blood draw, Toure swore at him. Probably something like, shut the hell up, you freaking commie, beep, 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 beep. Thus, the officers were faced with a dilemma. Well, no dilemma for me, but CHP was a dilemma. They could not remove the handcuffs because Toure was still out of control, but they could not wait for him to settle down because that might take hours, and meanwhile, the alcohol in his bloodstream would continuously degrade. Now, this has been a point of contention in law for a while. Is there an exigency to force blood because your body is destroying evidence? It used to be that's what we would use. Evidence was being destroyed if they refused to do this. Now, evidence of the DUI wouldn't be enough to force a blood draw, but when there's injuries or death, then this evidence is critical to prosecute him of the crime of murder or serious bodily injury. Therefore, we don't want to have evidence destroyed. And if we don't get blood immediately, evidence is being destroyed. So we need to go in and force and take blood. That's the exigency that we used to use in this case. So a sergeant approved a forced blood draw. Maybe the CHP has to have a sergeant do it. The results of the test were 0.15, and 0.8 is the limit, so he was almost 2 times over. Toure was charged with, among other things, DUI with injuries and resisting arrest. A jury found him guilty, and the judge sentenced him to almost 5 years in prison. Oh my God, poor Toure. On appeal, Toure argued that the results of the blood test should have been suppressed because the officers failed to obtain a warrant. Now, how long does it take to get a warrant? Anywhere from an hour to 2. Now, there is a calculation that you can do that most bodies will burn and destroy 0.02 of alcohol per hour. So if he was drinking and he was a 1.5, if it took me 2 hours to get the test and he came back a 0.11, I could articulate and testify as an expert, as a drug recognition expert, that, look, there's plenty of tests that show the body removes alcohol at a rate of about 0.02 per hour. Therefore, it took us 2 hours to get the blood draw. When we took the blood draw, he was a 0.11. Therefore, when he had the accident, if we add 0.02 per hour, that would be 0.4. We add that to the 0.11, and we get 0.15. I could articulate that, and many officers could, and would that not have been a better way? Had somebody been dead, I think it would have been a better way. But some would argue, you know what? A defense attorney is going to eat that up and say, my client doesn't burn it that fast, and maybe burns it slow, and maybe he stopped drinking earlier, or maybe he just started drinking, he was going up and he wasn't going down, therefore your test is bullshit, therefore I want the whole test thrown out. So that's the problems that we're faced with. It's not so much that cops want to be tyrannical and beat the shit out of people and take their blood, but at what point do you say, let me get a warrant, or screw it, you know what, we need to get blood from this guy, these people may die, he already been injuries, let's take blood. Okay, so this motion was based on the U.S. Supreme Court 2013 ruling, Missouri v. Manili, in which the court ruled that the dissipation of alcohol, which is what I was just talking about, dissipation meaning he dissipates 0.02 per hour, from the bloodstream does not, in and of itself, constitute an exigent circumstance. So it sounds like, if I were to go read this court, and this is why when you're trying to understand law, you have to go back and read the rulings that the courts are relying on to make their new ruling. And if you don't understand this one, you don't really understand this ruling. So I'm assuming by reading this that McNeely, they forced blood draw, and they said we forced it because we knew the evidence was just dissipating. And the court ruled in this that does not constitute exigent circumstances that would justify a warrantless blood draw. Okay? So that's what they're using. Instead, the court ruled that there must be some additional circumstances that reasonably indicated that a delay in obtaining the blood would significantly undermine the reliability of the test results, and in making that determination, the court said the relevant factors include the practical problems of obtaining a warrant within a time frame that still preserves the opportunity to obtain reliable evidence. The question then was whether such practical problems were present in this case. What did the court rule? I can assume they ruled in the officer's favor. I think the officers were reasonable. The Court of Appeal ruled, it noted that in addition to the dissipation of alcohol, meaning that there were other factors, and they're probably going to list them here, in the bloodstream, the following additional circumstances justified the warrantless blood draw. 1, the officers were delayed at the scene because Toure had caused injury, and that required some attention. Okay, I agree. You want to take care of the injured first. So that slowed them down at the scene. 2, Toure was combative and required them to be physically restrained. I don't know if that, I guess you could say that delayed them drawing blood. So we already have 2 factors that are delaying it. 3, it would have been dangerous to try and administer a field sobriety test on a combative arrestee. I agree. So that detained the test. I'm not sure it detained the blood draw, but I guess it would reasonably detain the blood draw. And 4, Toure refused to tell the officers when he had stopped drinking, therefore making it difficult to estimate the degree of intoxication. And I kind of talked about that is when you drink alcohol, if I drink 4 drinks in an hour, you get 0.02 per hour. That puts me at a 0.08. And if I burn 0.02 per hour, I wouldn't be 0.08 after 4 drinks. I would be 0.06. However, if I ate a big meal afterwards, it slows my process of the alcohol. If I drank on an empty stomach, it speeds up the amount of alcohol. So those factors will determine on how when I'm trying to do my conclusion, if I wait and then I say, well, going back 0.02, etc. 0.02 is an average, but there's other factors. What are the other factors? When did he eat last? When did he eat? What did he eat? How much did he eat? What's his burn? Does he have a high tolerance for alcohol? Does he normally drink a lot? What is his body? How was his FSTs? Would they show he was really? Because somebody may drink 3 drinks and not be able to walk a straight line. Somebody can drink 6 drinks and walk a straight line perfectly. So without all these factors, these are things that the court took into consideration. And 5, it was necessary to keep Toure restrained at the bar so obvious because he continued to be combative. I don't know if that really mattered about them getting a warrant. Keep him restrained for an hour to go get a warrant. Anyway, consequently, the court ruled that there was sufficient exigent circumstances to justify a warrantless. Remember, we're always talking about why didn't the cops get a warrant? If they don't have consent, they need a warrant. This guy did not consent. They didn't have a warrant, so the only other way to get evidence is through exigency. And according, it affirmed Toure's conviction. Alrighty? Hopefully you're getting a better understanding now. We're in about 6 or so to where you're really starting to get the concept of what exigent is. It's not just a definition. Well, cops should know and what well, it's not just a definition. It depends on a lot of factors. All right? That's the purpose of this series. Wait for the next one. And we'll end that there, and we'll see you on the next one.